This is commonlawyer.com, and this is part 15 of a series of unknown parts as we move along. We don't know how long it will take to get through our Constitution, but we're attempting to discover, blow by blow, provision by provision, clause by clause, whether the Constitution of the United States is consistent with the provisions of God's law written, known as Holy Writ and known as the Bible. We left off last time in Article 1, Section 3, Clause 4, which says as follows: The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. Now, this is the first introduction the Constitution gives in the course of its provisions of the Vice President of the United States. And the reason it does it here in this first article is because the Vice President is a part of the Senate and has a function there. And this first article is about the Congress of the United States, of which the Senate is one of the branches of that branch of government. And just for a quick overview, the second article of our Constitution is about the President of the United States, or the presidency, and all of the details that it reveals there. And the third article of our Constitution establishes and is about the Supreme Court of the United States. Now, notice here that this provision says that the Vice President of the United States, of which we don't know much about at this point until we get to the executive power article, Article 2. This president only has a vote in any matter coming before the Senate if the votes are equally divided. It says that he shall be president of the Senate. What that means is that he shall preside over the Senate. But over the decades, the practicality of the matter has become that he seldom ever does that, except on special occasions. But his tie-breaking vote is powerful, and if the Senate is hung in their decision, if it's an equal vote on both sides of any given matter that is in question, he has the power to decide that matter. So those that don't want that to happen would be careful and calculate very, very closely whether or not there will be an even number of votes on any different side of a particular matter. However, to try to do that is to speculate about the future. And if someone else who wants the vice president to break that tie because he knows how he'll vote, if he wants to try to ensure that there are an equal number of votes on any given matter, then that person or group of persons will try to do that. It becomes, again, a game of procedure. And procedure is everything in our Constitution. Our Constitution provides, it not only establishes the branches of government and the offices, but it provides the procedure that is required, called at common law due process, for any action that is taken. And good procedure, says our common law, makes good law. This, by the way, is a decision-making power. It is a vote, but it is a vote that is conclusive as to the power of the United States Senate. And it is akin, in a way, to the veto power of the President of the United States. The Vice President is one of the men that exercises or has the power to exercise executive power in the event that he would become president. In the meantime, he is part of the Senate. So in reality, the vice president has no executive functions as long as he remains vice president. In that sense, he is not part of the executive office. So as a technical matter and as a de facto matter, in fact, the Vice President of the United States, his presiding as president over the Senate and exercising power there of different kinds, controlling procedure even if he decides to, is no violation of the separation of powers doctrine of common law government as between the legislative and the executive powers. Article 1, Section 3, Clause 5 says, The Senate shall choose their officers and also a president pro tempore in the absence of the vice president, or when he shall exercise the office of the President of the United States. In the event something happens to the President of the United States and the vice president does become president, then it says he is no longer qualified to exercise his office as presider over the Senate. Why is that? Because to do so, the ratifiers of the Constitution judged was too strong a violation and a confusion of the separation of powers. To try to illustrate this a little better, if people are familiar with the Parliament of England, more accurately now the Parliament of Britain. The Prime Minister of Britain is the chief executive officer de facto of Britain. But it isn't said that in reality the sitting monarch, whether it be queen or king, has power beyond and above the prime minister of the country. Well, as long as the prime minister is also a member of parliament, that is a confusion of the legislative powers with the executive power. But to make matters further confused, the crown, whoever that may be at any given time, is also a part of parliament. As a matter of fact, in England, it is believed that Parliament has no sovereignty unless the Crown lends that sovereignty to Parliament. Therefore, they have made the Crown part of Parliament for that very reason, and then said that Parliament is absolutely sovereign within the jurisdiction of the realms of Britain, and bows to no other power on earth. Well, within that British way of doing things, there is separation of powers that are unspoken, and even the power of the Crown is unspoken. But as a matter of fact, the crown does have power. It's seldom ever used. Probably the last time it was used was just before World War II, but nonetheless, it's potent. And for that reason, the crown is called the potentate, the one who is able, who does have the power, whether or not the crown chooses to use it, and seldom do they choose to use it. It has become the unspoken and unwritten law in England that they do not do that. Just as in England, Parliament claims absolute final sovereignty over everything in England, but at the same time, Parliament bows to the opinions of the courts on most occasions, maintaining and allowing an independent judgment of courts and separation of powers and dissenting opinions, which are not allowed in a civil law country. But in America, we're more persnickety about that, and we demand a clear separation of powers. We won't allow the vice president to be president and serve as president over the Senate, and able to exercise any tie-breaking vote. Some of these things of which I speak and I notice here are the checks and balances, not all of them, but some of them, of which we hear about so much when we're in school, when we're taught about the Constitution. The more one reads our Constitution, the more one sees that these checks and balances are pervasive. Sometimes they're expressed, sometimes they are embedded in what is said there, but they're everywhere to be found in the document we call our Constitution. Again, everything in our Constitution was calculated as best as the people drafting it could calculate to divide power and to depend upon people's pride and conflict to keep government from exercising too much power at any given point, and at all events, depending upon the depravity of man to keep power from migrating into the hands of any single will, whether the single will of one man, a small group of men, or an entire bevy of men called Congress. Now, today I think we need to look at it a little bit different in that people who are outside of government have taken over the control of government without holding any government office. Indeed, power has migrated into their hands, and they do not allow anything in government to happen but what they want it to happen. In short, we are in the same position now, almost identically, as the American colonies found themselves just before the fighting of the war with Britain to remove themselves to succeed from the British Empire. In fact, by the time the Declaration of Independence, falsely so called, really the word independence doesn't exist anywhere in the title or in the document itself, but I like to call it the Declaration of 76. In that declaration, it lists the train of overt acts, that is, as it says, abuses and usurpations, proving King George's conspiracy with England's central bank money cartel and offshoot trading monopolies. These powers, using the raw force of the British Navy, the most powerful in the world at that time, and of the British Army, the best equipped and best trained army in the world at that time, using those forces to replace common law courts and government in the American colonies with civil laws, international, admiralty, and martial law, rule by distant decree, searches without warrant, tribunals without due process, and criminal convictions without the jury. The same abuses and usurpations that are now afoot in the United States. Today, much as then, dependents of the powers that be displace our common law government with civil law under its many labels. Administrative, admiralty, international, canon, Islamic, Talmudic, and martial law are all forms of the Babylonian tradition, tracing back to the law of that city. To be sure, martial and admiralty law are needful to govern soldiers at war and men at sea. History, however, speaks very clearly. Any use of civil law outside such constitutionally common law defined activities seeks only to dominate, abuse, and fleece other people. And don't forget that when we say that something is a common law freedom, we are saying that it is a law discovered in nature that nature's God had put there. And to believe and understand that our common law is an expression of our understanding of the law of nature is to also attach the law of nature's God to our Constitution, because there is no question that our Constitution is an expression of that part of the common law called common law government. Today, as pertains to the United States government is dominated by government-dominated corporations. It goes both ways. Untold agencies, swarms of bureaucrats, codes of countless rules, executive orders and decrees, warrantless searches and seizures, administrative and foreign tribunals, all without due process or trial by jury, or just feigning those things, and these now form a long train of abuses and usurpations, proving invariably, I'm quoting from the Declaration of 76, pursuing invariably the same object, evinces a design to reduce these states, these United States, under absolute despotism. What is despotism? It is the government of despots. What is a despot? It's an old Greek word. And by the way, the New Testament uses the word. Peter the Apostle uses it in one of his epistles. He uses the Greek word despotes. And he uses that word to describe God in the man of Jesus Christ, in the form of the man Jesus Christ. When Jesus Christ returns, he says he will return as the despotes. What is a despotes? Well, a despotes, as we would say in English, a despot, is a ruler who has gathered all three powers of government into a single will, into a single set of hands. The legislative power, the power to make law, the enforcement power, the executive power, the power to enforce law, the power of raw force, and the judicial power, that is, wraps it all together, the power to decide ultimately and without appeal right from wrong for other people in individual cases. Any person who has that absolute power as to decide right for wrong in individual cases has the power, in the Greek sense of the word, of a despotes. Now, I hasten to add that the word despot in English has taken a bit of a different shade of meaning, because it means rule in an oppressive and violent, cruel way. But the Greeks had that meaning to the word too, and when it's used of Jesus Christ, Peter uses it in the New Testament, he refers to him returning again. Because when he returns again, he will not return in the office of a suffering servant. He will return in the office of a warrior, and he will annihilate all those that oppose him in any way. And in the end, the Bible says, he will force every knee to bow and every tongue to confess that he is absolute Lord. And rightly so in his case, and in the case of no other, but in his case, because he is God manifest to men in a form that men can understand. That is, he is a man like us, born of woman. But as it says in our Declaration of Independence, and the implication there, it's assumed, and rightly so, that anyone else who takes upon that power over other people is a cruel and godless downright demonic despot. And to see examples of that played out, we can see it in what the Nazis did before and during World War II. They were cruel, especially the SS troops, fashioning themselves after the Greek warriors who deemed women unclean and cohabited only with men as homosexuals in order, as they said, to keep themselves pure from women, known today as the Spartans. The Nazis fashioned themselves after them and took on the same sex perversions and the same cruelty that went with it toward other people. As a footnote, many of those SS troops then were hired by the United States government instead of being executed or jailed for life because the United States had no intelligence on Russia. And all of a sudden, the United States faced an enemy called Russia. The Nazis knew all about them, had files on every one of them, and knew how to deal with them. And so the SS troops had been involved in that, and the United States, with those men, hired them to begin what is now called the CIA. And the subversion and the cruelty that is now attached to the CIA, they are the ones that are involved in torture and other nefarious activities of which our eyes are spared and which they take great pains to hide from the American people, are part and parcel of despotism, as it's understood in the hands of any person but God himself. As a final note to that, when Peter the apostle uses that word despotes, he calls Jesus Christ the only despotes. There is no other, and anyone else who would assume to fill that role is ipso facto a usurper and a man or woman who's warring against God. Now it says here in Article 1, Section 3, Clause 6, that the Senate, that is, of the United States, shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. There's that word preside again. It means to set as president, that is, someone who presides over something. And no person shall be convicted without the concurrence of 2/3 of the members present. What is impeachment? By the letters, the word impeachment means to catch another person by the foot. Like most words, it's graphic and concrete if a person will but take the time to look up the word and find out how it was originally used. And that meaning, as with most all words, is threaded in a symbolic way throughout its uses. Thus the House of Representatives, by impeaching an office holder, catches and holds him for the Senate, which will then try him for the wrongdoing which the House of Representatives' articles of impeachment charge him. Impeachment, then, is analogous in our common law tradition to indictment by a grand jury. The grand jury indicts a person, thereby catching him by the foot so that he can be tried. Without the indictment, trial is not to proceed. By the way, that's what our Constitution says, too. Trials for crimes at the federal level are only by grand jury indictment. Well, here, trials following impeachment. Impeachment is the House of Representatives catching the offender by the foot, or the accused offender, and then the Senate doesn't impeach anybody. They try him, whoever is impeached, by vote. So I need to repeat the language here just for clarity. It says the Senate shall have the power to try impeachments. The Senate doesn't have the power of impeachment. It has the power to try a man who's been impeached. And it says no person shall be convicted without a 2/3 majority vote of those members of the Senate present. Now the question may be asked here, is it biblical that our legislative powers can remove an office holder from office by the process of impeachment and removal by vote in the Senate? Well, one thing we can notice real quick, again, being a common law country and our Constitution being a document about common law government, which fundamentally is a way to limit the power of government, it emphasizes in the spirit of the common law not result, but process. And the process here is clear. Any trial to be removed from office must come after impeachment. And no one can be removed from office except by 2/3 vote. Very specifically it says of members present. Now I believe just 2 presidents have set for trial of impeachment since the beginning of our country, way back in 1787, when the Constitution put this on paper, anyway, about the power of impeachment. And that was Vice President, then become President, Johnson, who was from Tennessee and became president after Abraham Lincoln was killed. And if my memory serves me correctly, I believe that he missed removal from office by one vote. And many believe that he didn't commit any crimes or misdemeanors, as our Constitution requires, but he did refuse to be as cruel and hard on the defeated Southern states as the radical New England existentialist wanted him to be. He continued the policies then in place of attempting to heal the wounds and move on. Now, if God himself put men in office, man's impeachment and removal of such a person would be unbiblical. Under the principle that is a law of nature, it's never been wrong, it's always been affirmed as right in every instance that I've ever read, and that principle is this: he who has the power to give has also the power to take. Put another way, he who has the power to appoint also has the power to disappoint. That principle holds true throughout our common law tradition, whether you're talking about contracts, whether you're talking about wills, or whether you're talking about the power of appointment that is inherent in our common law of trusts. Job affirmed this. Job was suffering because God allowed the suffering, and he said this in the midst of his suffering: "The Lord giveth, and the Lord taketh away. Blessed be the name of the Lord." He didn't complain about it, because if God took his life, God, being the giver of life, was the only one that had the right to take it. By the way, it still stands true. Life is not to be taken unless by God himself or at his direct orders, and his direct orders are set forth in his way pointed out. But even in those cases, due process better be followed, and the two justifications for taking the life of another are war and capital crimes. But I see clearly now that if the due process that God requires is followed, neither war nor executions for capital crimes would hardly ever occur. Not because the crimes didn't occur, because due process would prevent capital punishment from being executed for capital crimes. The Bible's clear on that point, and our Constitution is just as clear. The Bible says that unless the accuser, whether it be the prosecutor or the witnesses, is willing to initiate with his own hands the execution should not take place. And that is why, for example, in John chapter 8, John records the incident of the woman caught in the very act of adultery, a capital crime. And the religious leaders of that day, the Pharisees, brought her bodily to Jesus, presented her, and said, "We are witnesses. We saw this woman in the very act of adultery." Now, the Bible doesn't say how she did that. For all I know, they set her up, and while one of them got involved with her, all the rest watched. Some people believe that, and I think there's grounds for that in the text. But at any rate, they were witnesses. And Jesus, you remember, said, "Well, if that's true, you're the witnesses, you're the accusers, and the law of God, in the writings of Moses, demands that you initiate the execution. So you throw her out there, and whichever one among you who is without sin," what sin? Well, likely the sin of adultery with this woman. "Any one of you that's without sin with this woman, you throw the first rock," because that's what the law of God demands. And it says they were shamed, or they walked out, appeared they were shamed. They refused to do it. Again, due process is the important point here, not result. Jesus said, "You fellows are too quick to get to the killing. Why don't you stop and observe the process that God in his mercy demands be observed?" Not only does the accuser have to initiate the execution, one accuser isn't enough. There must be, says the Bible, two witnesses. Not two people who heard about it, two people who saw it with their own eyes, their own sensory perception, and therefore could testify to it. That also seems to preclude circumstantial evidence, doesn't it? Seems to me it does. Pretty thin stuff. Well, let's take war. Would that occur if due process were followed? When should the United States go to war? Well, we're at war right now. Been at war for a dozen years. Before that, we were in Vietnam, and we were at war there for pretty near that long. And before that, we were in Korea. And in all that, thousands upon thousands upon thousands of young men lost their lives, young Americans, not to mention the hundreds and hundreds of thousands of other people in those countries that lost their lives that probably didn't have a clue what was going on. Well, I guess we didn't have much of a clue either. All of those wars were undeclared, and as undeclared war, they were wholly unlawful, wholly unconstitutional. If the United States wants to go to war, our law and our standard says fine. Just follow the process. Have Congress vote a majority to declare war, then we've got a declared enemy. Then, if treason is committed, we can punish it, even among those who like war so much. You know, it's been said that presidents make war, but even more importantly, war makes presidents. Well, let me put that in the old terms. That's the way we'd say it. Kings make war, and war makes kings. And the reason presidents make war is because war makes their power increase. It makes them more presidential. Or so they think. There is nothing crueler, nothing more wicked than men in offices of power that blink their eyes at the killing of their own people and the killing of other people in other lands without following the process that law requires before taking it upon ourselves to be part and parcel to the murder. And that's what it is, clearly, murder of other people. The Bible, as with the common law, is all about due process. I'll repeat it again just in case somebody didn't hear the other presentations. The phrase in Article 6 of the Constitution that says the Constitution is the supreme law of the land is lifted out of Magna Carta, where in Magna Carta it clearly refers to due process, which is just another word for common law. And it's put in our Constitution. The word supreme is not a superlative, it's a comparative. Compared to what? Well, the Constitution compared to any laws that are contrary to, not any laws that are offensive to, it says contrary. That's quite another matter. That's two standards of law that one cannot obey at the same time. That is, to obey one is to disobey the other by definition. Indeed, as we go through the Constitution, I feel like a broken record for those of you that have listened to the presentations before this. Those of you that haven't, you haven't got that sense about me yet, but I have discovered that there is a universal in most things, and when it comes to law and government, there is a universal, and that universal is God. And the other universal that is equated to God are the first principles of His Word. And His Word comes to us by two avenues. Number one, His Word written, which is His law written. It is His standards, the way pointed out, the Hebrew word Torah. An all-encompassing word. It comes in many forms written. It comes in poetry. It comes in historical narrative. It comes in wisdom literature, as we call it. It comes in the proclamations of doom and judgment upon those that have violated those standards. We have 17 prophetic books, really 16, not counting Lamentations, it's included in that, but 17, 16 or 17, depends how you look at it, plus prophecy scattered all through the Bible. Deuteronomy is a book of covenant, constitution, and law. It is a constitution. It is an agreement, but at the end of it, it has prophecy about what will happen if one thing happens or what will happen if another thing happens. All of those things tell us what the law of God is. It does it in writing. The first avenue, the written Word of God, and then the unwritten Word of God, that God teaches us His standards and He establishes law in His creation. And at the heart of all of that revelation, those tandem manifestation of God's character, at the bottom of it all is due process. And even as we go through the scriptures, the word mashpat is used over and over and over, and it's translated different ways, but it always has a thread running through it, meaning the same thing. The process or the procedure that is due to who? Due to God and due to the one to whom He has granted rights. And any right that you're granted is jurisdiction, and that's responsibility. And any law that prevents you from exercising your God-given right, which is your God-given stewardship, is wrong. It is an unlawful law, for lack of a better way to say it, because of our absence of words and our unavailability of words that would describe such a concept. This is Brent Allan Winters, commonlawyer.com, and you can go to the website and find out more of these kind of things about our Constitution, about our common law, and about our Bible. Next time we'll begin with Part 16, Lord willing.